Hello everyone, welcome back to the channel. Today is Sunday and in last Sunday's class we discussed some questions and answers, basically MCQs on introduction and background of the Constitution of India. So we covered till question number 7. Today we will continue with the next part. Today is 26th of April 2020. Today is a Sunday and we will start with the second part of this Q&A or multiple choice questions on Constitution of India. The questions that we will be discussing today are based on the preamble to the Constitution of India. Today we will cover till question number 32 and all these questions are from preamble part. So apart from giving you the answer, I will also be explaining you the concept, why only one of these options is correct and why the remaining ones are not correct. And also we will look into the basic topic or the provision or article of the Constitution from where that particular question is being asked. So we will start with question number 8. That is the first question from preamble part. It says the text of the preamble to Constitution of India aims to secure, that means preamble that we have to the Constitution of India as an introductory part to the Constitution, right? So what is it that preamble to the Constitution of India aims to secure? What is it that the preamble to the Constitution of India provides us? So let's look at the options that we have. There are 4 options. Fundamental rights to all citizens, all individuals. Fundamental rights to citizens of India. Now, why these 2 options are mentioned, that fundamental rights to all individuals and second is to citizens of India? Because these 2 are different options. When you read about the fundamental rights mentioned under part 3 of the Constitution of India, part 3 of the Constitution that talks about fundamental rights. So some of the fundamental rights, for example, Article 15, Article 16, Article 19, then 29, 30, these rights are given only to citizens. So it would be mentioned, the state shall not deny to any citizen. That means that particular right is available only to citizens. It is not available to any citizens, any individual. But when we say individual, that means that particular fundamental right is given even to foreigners. So are there any fundamental rights under the Constitution of India that are given both to foreigners and as well as citizens of India? So are there any fundamental rights that are even enjoyed by foreigners? Yes, there are certain fundamental rights. For example, Article 14 that talks about equality. Article 21 that talks about protection of life and personal liberty. So even if a foreigner is visiting India, we cannot just kill that person because that person is not an Indian. He do not have a fundamental right. We cannot just confine that person in a room or in anyone's custody without any valid reason. Why? Because even a foreigner will have certain fundamental rights like equality and Article 21, protection of life and liberty. Now, when I say equality, you may ask that, for example, if a person wants to enter in any tourist spot, right? For example, a zoo or any science museum or any other places that we have, the tickets prices would vary for foreigners and for Indian nationals. So how is it equality? If you ask me that question, that is not what Article 14 is talking about. What is Article 14? So Article 14 is about equality before law and equal protection of law within the territory of India. That means, for example, wearing helmet is compulsory in India. Both the persons should wear helmet. For example, in the state of Karnataka, it is compulsory that both the passengers should be wearing helmet when they are riding. So if that particular law is applicable, that would be applicable to everyone, even to foreigners, even to Indian national. That is what is equality. Under law, everyone is treated as equal. If there is a law under which any protection is given, that also would be same. If there is a law that, for example, Motor Vehicles Act, right? If Motor Vehicles Act is providing for any sort of compensation for any hit and run case or any traffic violation or anything, that particular protection would also be applicable to both foreigners as well as Indian nationals. For example, a foreigner comes to India and goes to visit Goa, and on his way there is some accident that he is a victim of some accident while he is going to Goa. So what happens? All the people who were traveling by that particular bus, they got compensation. So same amount of compensation should be given to the foreigner as well. That means equal protection of law and equal treatment in eyes of law. So this is something that is available both to foreigners as well as Indian nationals. Similarly, Article 21. Article 21. This is also available both to foreigners as well as Indian nationals regarding life and personal liberty. These rights are available both to citizens of India as well as foreigners. So now the question is the text of Preamble to Constitution of India. So is Preamble to Constitution of India providing any fundamental rights to anyone? It is not providing. So these two options are not correct. It is not providing fundamental rights to individuals, neither is it providing fundamental rights to citizens of India. Third option that we have is dignity of individual and unity and integrity of the nation. So this is what we will see even in the preamble, right? Content of the preamble. So this is what the preamble to Constitution is providing: dignity of individual and unity and integrity of the nation. So option 3 is the correct answer. Preamble is not talking anything about security of service to government servants. This is also not the correct one. So the text of the preamble to the Constitution of India aims to secure what? Dignity of individual and unity and integrity of the nation, apart from the other things that we mentioned in our class on preamble, discussing content of the preamble. We will move to the next question now. Which of the following statement is true? So there are 4 statements given regarding the preamble to the Constitution of India, and you need to select which one is the correct one. Preamble to the Constitution of India is enforceable in Supreme Court as well as High Court. Preamble to the Constitution of India is enforceable in Supreme Court only, is not enforceable, and is enforceable only if President gives his consent thereto. When we were discussing about preamble, we discussed that preamble is not providing any specific provision. It is not providing any rights, duties, obligations, or any powers or functions to anyone. What preamble is? It is basically an introduction to the Constitution. It is just telling us about the aims and aspirations of bringing this Constitution into picture, right? So that means preamble is not giving us anything. So what we will enforce going to Supreme Court or to the High Court, right? Because if it is a question of, for example, part 3. Part 3 is providing us some fundamental rights. If that right is violated or any of those rights are violated, we can enforce that by approaching the Supreme Court and High Court. But in case of preamble, it is not providing us anything. Then what we will enforce, right? So the first 2 options are not correct. We cannot approach to the Supreme Court or High Court, and also we cannot approach to the Supreme Court. Third is preamble to the Constitution is not enforceable. Fourthly, preamble to the Indian Constitution is enforceable only if President gives his consent thereto. So this option is also not correct. What is correct is the third option. that it is not giving us anything, so there is nothing that we can enforce. So preamble to the Constitution of India is not enforceable in any court. Even when you read the text of preamble or the content of preamble, there is nowhere the term enforceability or courts or anything is mentioned. It is just an introductory part of the Constitution. We will move to the next question now. That is question number 10. So question number 10 is regarding, in which of the following cases is secularism held as basic feature of the Constitution? Now, what is basic feature of the Constitution? Basic feature of the Constitution means certain features or certain specific provisions of the Constitution that we cannot amend or make changes. For example, under Article 368, we have the provision to make amendments to the Constitution, right? We can make amendments to the Constitution. So this part says that we can make changes to any part or any provision of the Constitution, but only one thing is to be kept in mind, is that we cannot change the basic feature of the Constitution. So what is basic feature? For example, we say that Constitution is supreme law of land, supreme law of land in India. So tomorrow there cannot be an amendment that says that from tomorrow Constitution will not be the supreme law of land, rather IPC would be the supreme law of land in India. So there cannot be any such amendment that changes the basic feature of the Constitution of India. That means supremacy of Constitution, we can say, is a basic feature or a basic structure of the Constitution which we cannot change. A democratic form of government is something that we cannot change through an amendment. Similarly, secularism is also a basic feature of the Constitution. If India is a country that do not recognize any religion as a state religion, that will continue forever. There cannot be an amendment that says that from tomorrow this particular religion would be the religion of India. There cannot be any such amendment. So the question is asking, in which case did the term secularism was considered as a basic feature of the Constitution of India? So it is in the case of S.R. Bomai versus Union of India. S.R. Bomai versus Union of India, we all know, right? It's a landmark judgment of the Supreme Court, wherein Article 356 regarding imposition of precedence rule was discussed in detail. So it's always a big debate that is misused by the political parties for their personal motives. And even if the state is, able to function properly, precedence rule is imposed in many cases. So similar thing happened in Karnataka when S.R. Bomai was the chief minister. Then he approached the High Court, Karnataka High Court also, and then he was not satisfied with the order and he moved to the Supreme Court. So this is the judgment of Supreme Court, wherein Article 356 was discussed in detail, and also in this particular case, the Supreme Court gave some guidelines in order to ensure that Article 356 is not misused. So what they did is that they gave some guidelines that would mention when imposition of precedent rule would be considered as proper and in which all situations it would be considered as improper. So in this particular case, only those rules or guidelines were also given. Apart from Article 356, the concept of secularism was also discussed in this particular case. So in this case, it was said that if the Constitution of India mentions that the states, right, the states should be secular through its actions or through its thoughts or anything, that similar thing applies even to the political parties. So if the state government has to be secular, then that same thing applies even to political parties. They are also bound to ensure that their actions or their schemes or any other things are not violating the basic principle of the constitution, that they are not something that goes against the concept of secularism, right? So there cannot be any action which is unsecular in terms of things done by political parties. So the answer to question number 10 is that the term secularism or the concept of secularism was held as a basic feature of the Indian constitution in the case of S.R. Bommai versus Union of India. So you should remember that there were two things that were discussed about the imposition of Precedence Rule Article 356 and also regarding the secularism, the concept of secularism, that was also discussed. So in this case, Supreme Court held that secularism is definitely a basic feature of the Constitution of India, and if any state government is found guilty of any non-secular act or non-secular actions or schemes, then it may be dismissed. So this was what was held in this particular case. Now we'll move to the next question. The words used in the preamble, justice, liberty, equality, and fraternity, are given contents by which of these parts? Now, in the preamble, if you see, you will find justice, liberty, equality, and fraternity. These terms you will find. In the preamble, what happens is that only these terms are used, that India tries to provide justice to people, liberty, equality, fraternity amongst people. What happens is that preamble is not providing any specific provisions that would ensure justice, liberty, equality, or fraternity or anything. It is the other parts of the constitution, the various articles of the constitution only, that ensures that these words that are used under the preamble are being fulfilled with specific proper provisions, right? So this question is asking which part of the Indian constitution is talking about or giving specific provisions relating to justice, liberty, equality, and fraternity. First is part 1 and part 5 of the constitution. So part 1 is regarding the state, right? That India is a union of states. So that part is not the answer. Regarding formation of state, then boundaries of states. So this is what part 1 of the constitution talks about. Again, part 5 is regarding the union, right? The appointment of president, who is a president, who is a vice president, how he will be appointed, Supreme Court, all of those provisions are mentioned regarding the central government offices and other things. So this is not the correct answer. This is not the correct option. Next is part 5 and part 6. So part 5 is regarding union and part 6 is regarding the states, that how a governor would be appointed, chief minister, then high courts, and all of those. Basically, part 5 is regarding the central government, all the officers and everything. Part 6 is regarding the same provisions for specific states. So this is also not the correct answer. These provisions are not talking anything about justice, liberty, equality, or fraternity. Part 3 is only about fundamental rights. So the correct answer for this question would be part 3 and 4 of the constitution, that is talking about it. Firstly, if you take the example of the concept of justice, it is part 4 of the Constitution of India, the directive principles of state policy, that talks about providing justice to people. For example, Article 38, it is a DPSP that talks about providing social, economic, and political justice for promotion of welfare of the people. So that is a provision that we get under part 4 of the Constitution. Then we have Article 39A of the Constitution that was added by 42nd Amendment Act of 1976. It provides for free legal aid to ensure effectiveness of, like legislations and schemes. It ensures that everyone gets justice properly. It is not denied to any person because of an economic or other financial or, like financial, educational, or any other reason. Even if a person is not aware about the legal services that are available, legal relief that is available, so that justice is not denied to the person. So it is part 4 of the Constitution that provides provisions for justice. Next is regarding liberty. So if you look at part 3 of the Constitution of India, take for example Article 19. It talks about various types of freedoms, right? Freedom of speech and expression, assembly, to form association, movements, residence, profession, all of those freedoms are given to people under Article 19 clause 1 of the Constitution. Then again, Article 20 also provides for some freedoms. Protection regarding convicted persons, right? For example, if a person is convicted of any offense, he shall not be given a punishment which is higher than what is applicable. He cannot be punished for something which was not a crime when he committed the offense. Then Article 21 regarding right to life and personal liberty. All of those provisions we have regarding liberty under part 3 of the Constitution. Again, equality. We have articles 14 to 18 of the Constitution, right? That talks about equality. For example, equal protection of law under Article 14. Under Article 15, prohibition of discrimination. Article 16 regarding equality of opportunity in matters of public employment. 17 regarding untouchability, and 18 regarding abolition of titles. So all of those relate to equality. And fraternity is mentioned under, actually it is not part 4, but it is part 4A in the fundamental duties that we have. The number 5, fifth duty is regarding promoting harmony and the spirit of common brotherhood. So which option is relevant with the question is that it is part 3 and 4. So part 3 and 4, both the fundamental rights and DPSP provides for specific provisions regarding these concepts. Now we'll move to the next question. India is republic because of which of these reasons, right? So we can select one reason because of which India is considered as a republic country. Head of the state is not a hereditary monarch. Now this is the correct answer. Who is head of the state? It is the president. President is considered as head of the state, and part 5 of the Constitution of India, Article 52 provides for a position of president, that there shall be a president of India. Then Article 53 talks about that the executive powers of the union will be vested in the president. So it is part 5 that provides for the position of president, and also part 5 mentions regarding appointment of the president, how he would be appointed and qualification and everything. So he will not be a hereditary monarch. Any person fulfilling those criteria or those qualifications can become a president, right? So because the head of the state, that is the president, is not a hereditary monarch, so India is considered as republic. It is not because constitution rests on the will of people. It is not that leader. So these are not the answers. So it is the head of the state is not a hereditary monarch. So India is called a republic. And also you should remember head of the state. Who is head of the state? It is president. Part 5 provides for the provision for appointment of the president and his position and all those details. Next question is, India is a sovereign because. So why is India sovereign? Of its supremacy in deciding matters, internal as well as external interest of the country. When we were doing preamble, we discussed this part, right? That India is sovereign. That means India is not under the control of any foreign authority or any foreign government. India is supreme and India is free to decide its matter, both internal as well as external matters. This is why India is considered as sovereign. We discussed this part with clear examples also. So if you haven't watched the preamble part video, I will leave a link to that in the description box below. You can check that so that you understand these concepts better. What all words are used under the preamble and what is the meaning of each of those terms used under the preamble to the Constitution of India. Next is, which was the last part of the Indian Constitution that was adopted by the Constituent Assembly. Now, when you study the constitution, right, there are various parts, various provisions are there. And what is the preamble? Preamble is basically an introduction to the entire constitution. So this is like you can apply your common sense and answer this question, right? Because preamble is the basic, like understanding or an introduction to the constitution. What happens is that all the other provisions should be there, then only you can write an introduction covering everything, right? So it is the preamble that was adopted last by the Constituent Assembly. That means when all the other provisions were finalized, then only preamble was accepted or adopted. Why? So as to ensure that everything that is mentioned in the constitution is summarized in the preamble. So the answer to this question is preamble. Preamble is the last part of the constitution that was adopted by the Constituent Assembly once the entire draft was ready. Next question is, in case there is a conflict between preamble and other provisions of the constitution, what will prevail? Now, what the preamble is basically giving us an idea as to the aims and aspirations of the people or the drafters of the constitution. So if there are provisions regarding equality, regarding liberty, for example, the fundamental rights that are given, right, under Article 14 to 18. Now, preamble is giving us an idea that all of these rights were inserted in the constitution just in order to ensure equality amongst people. What happens is that preamble is giving us a slight hint or an idea as to why that particular provision was being inserted. So in case there is any confusion as to why a certain part of the constitution or why a certain article was inserted in the constitution, what we can refer is that we can refer to the preamble and get an idea as to the motive behind adding that particular part or article. So it will be preamble that will prevail because it gives us an idea as in why that particular part, provision or article was inserted by the drafters of the Constitution of India. So the answer would be the first one. Next is the binding force of the Constitution of India is. What is the binding force? Is it sovereign will of people, parliament, objectives enshrined in the DPSP, or President of India? Answer is the sovereign will of people, which is binding. So people are sovereign in India, right? And the constitution, if you look at the preamble, you would see that the Constitution of India was enacted, adopted, and given to ourselves by us, right? So the main binding force in the Constitution of India is what? Sovereign will of the people. So this is the answer. It is sovereign will of the people. Next, the concept of the basic concept at the root of secular India is dharma nirapeksha, sarva dharma sambhava, both of the above and none of these. So this is very easy question, right? It is dharma nirapeksha. That means it will not discriminate on the basis of religion. There is no state religion. Every religion is equal. Same rights would be given. So this is the answer. Sarva dharma sambha basically means that, like all the dharmas are equal and harmonious with each other. So this is not the correct answer, but dharma nirapeksha is the correct answer for this question. Now we will move to the next question, question number 18. The preamble to the Constitution of India was adopted by the Constituent Assembly. So this is also similar to the other question that we did, that preamble was the last part that was accepted by the Constituent Assembly. Now this is also similar, that preamble was adopted by the Constituent Assembly after the draft constitution had been approved. That means once the draft constitution was ready, then only they adopted the preamble, just in order to ensure that preamble contains a brief summary of all the provisions that are there, and it gives us a clear idea as to why or what is it that we want to achieve by bringing this Constitution of India into picture. So these are not the correct answer. First one will be the correct answer. Next question, justice, social, economic, and political is. What is it? It is an ideal and enshrined in the preamble. So it is not guaranteed by fundamental rights in the Constitution of India, right? It is what? It is not guaranteed by fundamental rights, justice, social, economic, and political. It is guarantees to the people by writs. So writs are applicable only in reference to the fundamental rights. Directive principles of state policy taken into account while making enactments. So in DPSPs, you can find these provisions, but they are specifically mentioned in some provisions, right? So it is an ideal that is enshrined in the preamble to the Constitution of India, and some of these are given power by various DPSPs. And also you can select the third option, that it is an ideal that is enshrined in the preamble to the Constitution of India. That is the correct answer. Next is Indian Constitution is framed to work as what? It is framed to work as a federal system in normal times and unitary system in emergency. In normal times, it is federal. That means states are given, the state government are also given various powers to deal with matters that would affect them. But in terms of emergency, what happens is that central government to take over the charges, and it would become a unitary government. So it is federal system in normal times, but whenever there is a case of emergency or situation arises, union government may take over charges. So unitary in emergency times. Next is sovereignty lies in India with whom? Again, this is similar to this type of a question we already did. It is the people of India to whom sovereignty lies in India. If you look at the preamble to Constitution of India also, you would see that Constitution is given by us to ourselves. So it is the people of India to whom sovereignty lies. Next question, which of the following is correctly matched? So amongst these four, only one option is correct. Republic means head of the state is hereditary monarch. So republic does not mean it is hereditary monarch, right? It means that he is not an hereditary monarch. So this is not the correct answer. Sovereign means constitution rests on will of the people. So this is also not the correct option. Sovereignty lies with people, but sovereign means what? That we are free to decide for ourselves. This is not the right answer. Democratic constitution does not recognize legal supremacy of another country. This is not the correct answer. Sovereignty means that constitution does not recognize legal supremacy of another country. We are left with this option, that secular. State is without religion of its own. This is the correct answer. Secularism means state will not support or promote any particular religion, but for it, all the religions should be equal. If any provision or any facilities are given to one religion, same would be given to other religions as well. So this is the correct answer for question number 22. Next is, in the preamble to the Constitution of India, the word sovereign, socialist, democratic, and republic has been substituted by which all words? When we were discussing preamble, we discussed that there was only one single amendment that was made to the preamble, right? It was, which amendment was it? It was the 42nd Amendment Act. So that 42nd Amendment Act inserted certain words. So what were they? Socialist, democratic, and republic, right? Sovereign, socialist, secular, democratic, and republic were substituted for which word? Socialist, democratic, and republic. So this is the correct answer. Sovereign, socialist, democratic, and republic. These were substituted by sovereign, socialist, secular, democratic, and republic by the 42nd Amendment Act of 1976. Now, the word socialist and secular were added by which Amendment Act? So it is the 42nd Amendment Act. We discussed it many times, right? This is the 42nd Amendment Act and the only amendment made to the preamble to Indian Constitution, and it inserted socialist secular. Now we will move to question number 25. Preamble to the Constitution talks about justice. What all types of justices are there that the preamble to the Constitution of India talks about? It is social, economic, and political. These are the types of justices that the Constitution, that basically the preamble to the Constitution talks about. Justice, social, economic, and political. Next is, in which case the Supreme Court added for the preamble, it is the key to open the mind of the constituent makers. That means preamble is something that is a key to open minds of the constitution maker. As in, by reading the preamble, we can see what was there in minds of the constitution makers when they drafted the Constitution of India. It was held in Golaknath versus State of Punjab case. The correct answer is A, Golaknath versus State of Punjab. It was said that the preamble gives us a clear idea as to why a specific provision was inserted by the constitution maker. So it is considered as a key to open minds of the constitution makers. Next is, unity and integrity of the nation in the preamble was substituted by what? It is, unity and integrity of the nation was substituted by unity and integrity of the subjects. For this, you can refer to the preamble. Next is, preamble of our constitution is of extreme importance and the constitution should be read and interpreted in light of the ground and noble vision expressed in the preamble. It was Justice Sikri's expression, and he mentioned this particular opinion in the famous case of Keswananda Bharati versus State of Kerala. I will also discuss all these important constitutional cases in detail so that it becomes easier for you to answer these kind of questions, because you can definitely expect questions based on the case laws or what judgment was given, what opinions were shared by justices. So for that, we will discuss the cases in detail in some of our other classes. Next question is, the idea of preamble to the constitution is borrowed from which constitution? It is the Constitution of USA, from where that particular idea that we should have a preamble to the constitution was borrowed. We'll also do a video on the features that were borrowed from different countries. I will try to make a table so that it's easier for you to remember from which country what all provisions were borrowed. Next is, the word secular was added to the preamble in which year? Very simple, it is 1976, because there is only one amendment in the preamble, that is the 42nd Amendment of 1976. So any question that comes regarding amendment of the preamble, you can just answer it as 1976. Amendment Act is 42nd Amendment Act. Last two questions we will do now. 31. Question number 31. Justice, social, economic, and political is what? We already discussed a question similar to that. It is an ideal enshrined in the preamble to the Constitution of India, and it is given power by various articles and various provisions of DPSP. Economic justice. An important objective of the Constitution is embedded in the where. So it is mentioned both in the preamble as well as in the DPSP, right? So in both of these, this particular thing is embedded. Even the preamble talks about economic justice, and even the DPSP, even in DPSP, we have various articles talking about economic justice. So we will select both A and B. It is not fundamental rights. Fundamental rights are not talking anything about economic justice. So this is the answer for question number 32. That is the last question that we had on preamble to the Constitution of India. After today's class, we have covered two topics, introduction and background and preamble, and we have done a total of 32 questions. So I hope this part on the Constitution is very clear to you. And also you have got a fair idea as to what type of questions you can expect from these parts, like MCQ questions, what all things you can expect from these parts. So we'll continue next Sunday with some other topic from the Constitution of India, some other MCQs, and we will try to solve them in our next class. Thank you so much.